Hear ye, hear ye, hear ye. All persons have anything to do before the Honorable Justices of the Appeals Court, now sitting at Boston before the Commonwealth. Draw near, give your attendance, and you shall be heard. Now say the Commonwealth of Massachusetts, court is now open. Please be seated.
Good morning. Welcome to the Appeals Court. We have a special event this morning. I can't imagine you're all here for the two cases that are on the list, so I guess we should get to the important moment, which is to welcome our newest justice, Judge Chauncey B. I'd first like to recognize our Appeals Court colleagues who are here today, including some of our retired colleagues, our wonderful and dedicated staff, and Justice Wood's friends and colleagues. But most importantly, Justice Wood's wife, Lisa Kavanaugh, his eldest daughter, Carter, and his youngest daughter, Isabel, is in school today, but I know she is with us in spirit, but working on a French exam or something like that. We also are so pleased to have Justice Wood's father, Charles, and his stepmother, Marges Bacon, and I do see many of Justice Wood's former colleagues and friends, so welcome. It's a great pleasure to welcome Justice Wood as the newest member of the Appeals Court. He was nominated by Governor Maura Healey and unanimously confirmed by our Governor's Council and sworn in a private ceremony a few weeks ago. Joining me on the bench today, in addition to Judge Wood, is our Senior Justice Ariane Vuono, Justice William Meade, Justice Eric Neyman, and of course, Judge Wood. By tradition, the Appeals Court employs an expanded panel of 5 judges for the first case heard by our newest member of the court. After we hear the first case today, the panel will be reconstituted, and I will be joined on the bench by Justice Neyman and Justice Wood. Now for a little bit of background about Justice Wood. He grew up in Connecticut, graduated from Harvard College with a Bachelor of Arts degree in English, and then earned his J.D. magna cum laude from Boston University School of Law, where he served as the editor-in-chief of the Public Interest Law Journal. That should have been a clue as to what Judge Wood's career path would look like. He began his career in Washington, D.C., before moving to the Maryland Public Defender's Office. He had the smarts to move to Massachusetts in 1996 and worked with a number of firms where he specialized in indigent criminal defense. In 2008, Justice Wood founded the law firm of Wood and Nathanson, where he specialized in post-conviction litigation. He also served on the board of directors of Suffolk Lawyers for Justice and the Massachusetts Association of Criminal Defense Lawyers. We are very lucky to have Justice Wood join the court with such an impressive background. Here in the Appeals Court, we follow the custom that is used by the Superior Court in numbering our judicial seats in the order that they were created. Judge Wood, you are now the third person to hold seat number 17. That seat was first held by Justice William Cowan and most recently by Justice Milkey, who is here with us today. I should also note that counting all statutory and recall judges, you are the 85th justice to serve on this court. That might be your new lucky number. I will now ask the Clerk of Court, Paul Tuttle, to read your judicial commission.
To all to whom these presents shall come, greetings. Know ye that we, by our Governor, with the advice and consent of our council, confiding in the ability, discretion, and integrity of Chauncey B. Wood of Somerville, do hereby, under the provisions of Chapter 211A of the General Laws as most recently amended, and in conformity with our Constitution, constitute and appoint him to be an Associate Justice of the Appeals Court, to hold said trust during his good behavior therein, unless removed therefrom in the manner provided by our Constitution. And we do authorize and enjoin him, the said Chauncey B. Wood, to execute and perform all the duties, and he is invested with all the powers and responsibilities which by our Constitution and laws do or may pertain to the said office, so long as he shall hold the same by virtue of these presents. Witness Her Excellency Mara T. Healy, our Governor, and our Great Seal hereunto affixed at Boston this 18th day of December in the year of our Lord, 2024, and of the independence of the United States, 247.
Welcome and congratulations, Justice Wood. Now, I'm sure that you all want to stay for the arguments, but this does conclude our official induction of Justice Wood, so we will take a brief moment for those of you that would like to leave the courtroom before we hear the first case. Family and friends, you're more than welcome to stay. You know how to clear the courtroom there, Chauncey. They make these so heavy. I know. I'm not good at it at all.
Did Coke have COVID?
I don't know. I should say, while folks are filing out, if you want to take any pictures of Justice Wood on the bench, feel free to do that.
Cameras come out.
Just Photoshop me out. Stand up, take a picture, absolutely. Even our court officers are helping us out with photos. Thank you, Gio. I appreciate that. All right, so we should actually do some business this morning. I know counsel is familiar with the rules, but just very briefly, each side is permitted 15 minutes of argument. There is no rebuttal. I can assure you that we have read all of the briefs and the record, so you should get right to the substance of your argument. With that, I will call the first case on this morning's list, COMMONWEALTH versus JONAS FRANCISQUE. I'm sorry if I mispronounced that. Docket number 24P148. Attorney Harwood, good morning.
Morning. Honored to be here this morning. This is an appeal of a denial of a decision. Was an amended motion for new trial before Judge William Sullivan in Brockton's Superior Court. It's a murder two conviction, and I will get right down to it because there are really four categories of evidence here. This is a Brady issue. The original motion for new trial was an ineffective assistance of counsel in connection with DNA blood evidence. The original motion for new trial occurred post-appeal. There was an appeal here in 2013. And there was a testing of evidence of the victim's clothing. This was a stabbing death. And there was a comparison to both the defendant, Jonas FRANCISQUE, and to two other suspects, one of whom was Wagan Cagney, and the other one was a Mr. Polynice. And the original motion for new trial, what we uncovered was the Bode lab looked at this evidence, and they concluded that Mr. FRANCISQUE's blood was nowhere on the victim. They did have a sample of FRANCISQUE's blood with which to compare. But they did find out that there was the victim's blood on both Mr. Polynice's sneaker and two spots on the jeans of Mr. Cagney. Both of those suspects were observed to be involved in what was characterized by the Commonwealth as a melee upon the victim. So after that, the judge denied the original motion for new trial, saying basically, well, there's no evidence that either of these suspects was wielding a knife. That's what he said. So we go forward and pursuant to an information request, it's uncovered that basically all of the Brockton police reports were suppressed by then Sergeant Copenroth of the Massachusetts State Police. His explanation at the evidentiary hearing, which Judge Sullivan ordered, strained credulity. He said, well, these are handwritten reports. They were never typed. I saw them, but then I returned them to Captain Loud, and nobody ever saw them again. They were never turned over.
I don't think, Mr. Howard, I don't think the Commonwealth is challenging that they're exculpatory or they were withheld, so
right.
Let's get into it.
And Judge Sullivan held, basically looking at the three prongs, that the evidence was within the control of the Commonwealth. The evidence was exculpatory for two reasons, because it pointed to third-party culprits, not the defendant, and it would have supported a Bowden defense, because Copenroth admitted that he never followed up what was in the reports.
So it comes down to the third prong of the test, right? The prejudice prong.
It comes down to prejudice.
So let me ask you this question. I think we should get to the standard of review. You note in your brief, you say that this is de novo, but the judge here held an evidentiary hearing.
He did.
And the judge also took testimony from, among other witnesses, trial counsel. And the judge had to make, or did make, some findings. So why isn't the standard of review, at least in part, abuse of discretion?
Because I maintain that it's de novo, because all of the evidence was documentary except for the Copenroth testimony at the evidentiary hearing, and there's nothing.
What about the trial counsel's testimony regarding the impact, other defenses he might have raised, strategic concerns, things of that nature?
His findings don't go into that, though. He is in no better a position to determine prejudice from the suppression of the exculpatory evidence than this panel.
What case stands for that proposition? I know that you cite to Tremblay, Likas,
Mazza.
I think, and Mazza, but those cases either involved a situation in which the motion judge was not the trial judge as here, but they involved situations either where there was no evidentiary hearing or where the evidentiary hearing solely involved documentary evidence and affidavits. Again, here we had testimony.
There's testimony from Copenroth, but the police reports from the other two police officers, they mirror. It's all the documents. The Bode report is the Bode report. The police reports that were suppressed are the police reports. And as to Copenroth, there's nothing in his testimony that's in any way something that the judge had to evaluate. Copenroth admitted in this case that he didn't turn over the reports. The judge found all of those facts. So the real decision here is, under Commonwealth versus Pope, is there a substantial basis to believe that this evidence would have been a factor? Because the judge also found here there was a specific request for this evidence.
Could I ask you about the final piece, which to me is the most interesting, which is Major Copenroth's disclosure, I guess, in the evidentiary hearing, that he was aware that the large man with the afro standing outside was in fact a Wiggins Cagney, and he was, so in other words, we now know that Wiggins Cagney was holding a knife. So my question is that evidence, is there any evidence in the record that this knowledge was disclosed to the defense prior to the trial?
Zero. And in fact, I went through all of Copenrath's trial testimony. Nobody had any clue that the person who was wielding the knife at the scene was Wiggins Cagney. He's the gentleman who Bode found had blood on his pants.
Okay, and so if I could follow up, I'm sorry. You don't brief this explicitly, but it seems to me that there's a question how we treat that testimony from Major Copenrath. Are you alleging explicitly that that is exculpatory evidence, his knowledge that this was Wiggins Cagney and this means Cagney had a knife, and alleging that he suppressed that knowledge?
Yes.
Okay, and there never was a strike. Go ahead.
Yes, that it was also a suppression of Brady evidence, and it certainly was something that could be considered under the confluence of the factors test. That here you have another suspect with blood on him who is holding a knife, and I think what's critical is the pathologist said the murder weapon was a 3 to 4 inch knife, and that's exactly what Louis Asack described in the hands of Cagney at the time of the crime.
But where is that raised in your brief?
It's raised both in the opening brief and the reply brief.
Well, the police reports and the prison letter clearly are raised, but the testimony, as Justice Wood just described it, where do you raise that squarely?
In the opening brief, I discuss it when I talk about the confluence of factors test. In the reply brief, I talk about it both in the Brady argument and in the confluence of factors.
While you're talking about your reply brief, I know this is a little bit off topic, but Commonwealth suggests that you have waived the ineffective assistance of argument claim at page 37 of their brief, and you did not respond to that in your reply brief. So what is your view on the waiver question?
My position is it's not waived. Judge Sullivan certainly didn't treat it as waived. Their cursory reference to it is not something that I would suggest the panel consider, especially since Justice Sullivan wrote a 20-page decision and never found that there was a waiver.
Can I ask you a materiality question or a prejudice question? Accepting that either Wiggins Cagney, the testimony from Copenrath about Wiggins Cagney alone or with other exculpatory evidence is suppressed exculpatory evidence, and we come down to prejudice. It's important, I think, to your argument that blood, the victim's blood, was on Wiggins Cagney's pants. But I think the record evidence establishes clearly that Wiggins Cagney was involved in a bar fight with the decedent before the fatal stabbing out in the parking lot. What's your best argument for the claim that this blood was relevant material to this proving that Wiggins Cagney was involved in the fight out in the parking lot, as opposed to merely the bar fight?
I would say that the fact that the Commonwealth says he was in the bar in the fight hurts them more than it helps, because the pathologist said that the knife which was used to inflict a wound in the jaw in the bar is the same knife that was used to commit the fatal stabbing outside in the parking lot. Jonas Francisque was never alleged to have been involved in the fracas in the bar, yet Wiggins Cagney was. So my response would be the evidence of the bar fight, to the extent the Commonwealth claims he was involved, hurts and helps certainly the defense claim that this might have been a real factor in the jury.
Just to be clear, can I clarify? The examiner didn't say that it was the same knife, same size, right? Same
3 to 4 inches.
Right, same size, not that it was the same knife. There was nothing, no forensic evidence indicated that there was, other than the size and
Right.
the size of the wounds, right?
Right, although the pathologist did specifically testify that the knife that was used to inflict the wound in the bar to the jaw area was the same knife that was used to commit the stabbing in the parking lot. So if Francisque is not involved in the fight inside the bar, but Wagney definitely is involved in both. Because, to be clear, the judge said, well, there's no evidence that Wiggins-Cagney walked over to him. Everybody said that Wiggins-Cagney was involved in kicking.
So how do you balance that? How do you balance that against Moyes' eyewitness testimony that he saw the defendant stab him, the defendant's admission to Moyes that he stabbed him, the further statements he makes to the girlfriend, and the pile of consciousness of guilt evidence?
So cases come up, and one has to decide, would this evidence have made a difference with a jury? This case had deficits. Originally, Fernando Moishy, who had an immigration issue, exculpated Jonas and said he was not involved. The same with Joanna Raymond, the girlfriend, who had her own motive and bias. She originally told the police that Jonas was not involved, that it was Edison Caesar. Edison Caesar, if you recall, is the person with a black Acura, and the suppressed police reports said all of these 5 men who were observed by Louis Asack, Patrick Guerin, and Stephen Ellens to have assaulted and stabbed, I admit the report is general on that, pile into a black car. So,
I'm sorry, who said that the people in the black Nissan stabbed somebody?
no, they said that they said they observed an assault.
They said they're suspects
and that they observed that he had been stabbed. They didn't say by who, and that the 5 suspects then pile into a black Acura. And the black Acura most closely resembles Edison Caesar, who later in the evening says, I'm never going to go out again after that. So all of these are defense theories that could have been developed had this evidence been turned over to the defense, but it wasn't.
I have one other question for you before your time's up. I think you just said earlier that the defendant was not alleged to be involved in the fracas in the bar?
Right. It was a
Because Volume 4, page 87, Fernando Moishy testifies, he's asked about what's going on the dance floor in the bar, and he said, Josner pushed him first. Who else? Harry, Mel, and Jonas.
But there's no evidence of, it's an argument of Deriska over Melissa Serlin, who is the girlfriend. St. Just was dancing.
I understand that.
Yeah.
All I'm saying is you just represented to the court that he wasn't alleged to have been involved in the fracas in the bar, but there was evidence of that.
Okay. He was, I guess, one of 7 people, but the fight was between the boyfriend and St. Just, who was dancing with the girlfriend, Ms. Serlin.
And I think, unless the panel has any other questions, we're going to have to take the rest of the argument on your brief. Thank you so much, Mr. Harwood.
Thank you.
Attorney Hansen.
Thank you, Your Honor. If it pleases the court, Arne Hansen for the Commonwealth. I would ask that you deny or affirm the defendant's conviction and affirm Judge Sullivan's decisions on denying the motion for new trial. With respect to the defendant's arguments, the standard here before the court is significant error of law or abuse of discretion that comes from the Sullivan case, which is 478 Mass 369.
Can I ask why? I'm not sure I follow that. If, in fact, the Coppenrath's testimony about Cagney having the knife is exculpatory, and if it was suppressed, then why isn't that governed by the Murray standard, which articulates the Grace standard?
I would suggest that we look at Drayton, which is 479 Mass 479, which states that we have to accept the findings that are based at the evidentiary hearing, and this was revealed at the evidentiary hearing, and whereas documentary evidence could be reviewed by this court, where this court would be in the exact same position to review that evidence.
Sorry, I don't understand that. The fact that this exculpatory evidence was revealed for the first time at the evidentiary hearing and testimony. I get that. You don't get the benefit of the standard if we all agree that so preliminary question, do you concede that that is suppressed exculpatory evidence that was never provided to the defense?
Yes, that was revealed at the first time at the evidentiary hearing. I don't think anyone
So why
knew.
is that not governed? The fact, your argument, I think, is under Drayton that it was because it was revealed in testimony as opposed to some other method, you get a less favorable standard of review?
Yes, because the judge would have been able to consider how that evidence came out at the evidentiary hearing. You have witnesses in front of you, and you can evaluate that much better in person rather than just on a transcript.
I understand that there's a deference perhaps due to live testimony, but first of all, there's no dispute here that what Major Coppenrath was disclosing was true. Everybody agrees that what he was disclosing was, I knew that guy that Louis Asack was describing with the knife was Wiggins Cagney. Everybody agrees that that's accurate knowledge. So first of all, what's the deference? What is the dispute? And second of all, why is there any deference? And third of all, what does that have to do with the standard of review for the prejudice standard.
Well, I don't really believe that it has an impact on the prejudice standard. I think we're still evaluating it as whether or not this would have changed what was before the jury.
Right, so sorry, my first question was, what's the prejudice standard? You said it's something else. I thought it would be the standard established in Murray that governs suppressed exculpatory evidence for which there was no specific request.
Yes, I agree with you.
Okay, all right, thank you.
Now, with respect to prejudice, the defendant has failed to establish that there was any prejudice here. Now, looking at the police reports that were not handed over, some of these officers testified at the evidentiary hearing. It's clear that these are beat officers that are responding to the scene of what they believe to be a fight. It turns out to be a stabbing, which turns out to be a murder as well. These individuals took preliminary statements from Patrick Garrod, Stephen Allons, as well as Louis Asack. All of these individuals testified at trial. What they gathered from their quick interaction on the scene at that night is that they observed some of the people that were involved in this melee, and the evidence suggested there was between 10 and 15 people involved, fled in a black Nissan Maxima. If you look at the trial testimony of these three individuals, it's clear that they observed the melee, but they didn't see who actually stabbed their friend. That is important here because none of these individuals' testimonies went to the identification of the defendant. Furthermore, it's cumulative of what was presented at trial, that there was a melee and that people fled in multiple directions.
Right, but so focusing on Major Coppenrath's disclosure that Wiggins Cagney had a knife, it seems that that is crucial because it reveals a blatant contradiction between the one eyewitness, Fernando Moise, who says Wiggins Cagney was in the melee, and Louis Asack, who says Wiggins Cagney was not in the melee. Isn't that a blatant contradiction? How do you resolve that?
You can't resolve it. I mean, that would be for the jury to evaluate, but
so the one eyewitness has said something that's contradicted by somebody else. Isn't it also true that the one eyewitness initially told the police 4 days after the crime, his first time talking about the crime to an official, says Edison Caesar was the first guy to stab him with a beer bottle, and then admits, okay, I made that up because I was feeling police pressure. So the first thing he says is he falsely accuses somebody else. Did I get that right in the record?
That's fair. I mean, I would note that the autopsy showed that there was no glass in the victim's body, which showed that that statement was in fact fabricated.
But my point is he made a false accusation against another person, and that he admits he did that, but he made a false accusation against another person, which presumably undermines his credibility, right?
Correct, but that would have all been a live issue, and that would have been known at the time of trial, so it doesn't change anything post-conviction.
Absolutely, but when we're discussing the suppression of exculpatory evidence, specifically Major Coppenrath's disclosure that Wiggins Cagney had a knife, and we have to evaluate the materiality of that, and we look at the strength of the Commonwealth's case, we have a single eyewitness who's now admitted that he falsely accused somebody else and is blatantly contradicting Louis Asac. Am I right about all of that?
That's fair.
Okay, thank you.
With respect to Wagners-Cagney, there's no evidence that he was actually the individual that stabbed the victim in this case. He was identified by Louis Asac as someone who had a knife but was outside of the melee. But he was involved during, then we have other testimony which stated that he was involved during the fight in the bar as well as outside. But nothing puts the knife that individual yielded in the chest of the victim. The testimony that we have and the evidence that we have in this case comes from Fernando Moise, Ms. Raymond, as well as Mr. Legere. So the new DNA evidence really doesn't change any of that either.
I'm sorry, when you say that, I don't mean to monopolize, but I don't follow what you're saying. There's no evidence that Wagners-Cagney was involved in the melee outside. First of all, and correct me if I've got any of this wrong, my understanding is that Fernando Moise says he was in the melee, and the DNA evidence establishes that the victim's blood was on his pants. So I think those two pieces of evidence, and the DNA was not known to the jury, and the fact that he had a knife was not known to the jury. So those two pieces of evidence, at least, well, the first two pieces of evidence established that he was in the melee.
Yes, I agree with you on that point.
You're saying, you're just drawing a distinction between being in the melee and stabbing him.
Correct. There are 10 to 15 people that attacked the victim on that evening. One of them stabbed him. The person that stabbed him was the defendant who was convicted for stabbing him. We know that he stabbed him because one person said he witnessed it.
Fernando Moise.
Correct. And then he makes admissions to Fernando Moise after the fact, and several other witnesses, Mr. Legere as well as Raymond, he makes a statement saying that he did it to Raymond, and then Legere also saw him after the fact, and we see him cleaning up the blood off of his clothes, and then he makes a further statement saying that he needs to get rid of the knife and the bloody clothes. Several weeks later, he makes other statements saying anyone who talks to the police about this is going to get shot, to Mr. Legere, which made Mr. Legere feel very uncomfortable and unsafe, to the point where he required a police escort during the trial.
And am I correct that Fernando Moise is the witness who put, I'm going to pronounce his name wrong, but Harry, that's Kagan's Wagney, am I pronouncing that correctly? Is it Wagney?
Wagners-Cagney? Yeah, I'm not sure how to pronounce his name either.
In any event, Moise is the one who puts him in the fight both inside the bar and outside. Is that correct?
That is my recollection of the transcript. Now, what we have here that distinguishes other cases that have been overturned by evidence that has come out later or failure to investigate third-party culprit evidence is none of this purported new evidence that defense counsel failed to investigate changes the underlying basis of this conviction or undermines the credibility of Mr. Moise. In a lot of the other cases, such as Pope, Al-Qaid, Cowles, Drayton, those cases rest on the witness statements of one individual who may or may not have had credibility issues going into trial, and then post-conviction information comes out that destroys their credibility. And this court, as well as the SJC, then have found that that would entitle someone to a new trial, and we don't have that in this case.
I think you're saying Fernando Moise didn't have credibility issues. Is that a fair characterization of what you're saying?
Nothing changes his statements post-conviction.
Did he have credibility? I'm sorry. Did he have credibility issues at trial?
In the sense that, yes, he gave a different version of events when initially questioned versus what he ultimately testified to after trial.
And didn't he admit, I'm sorry, but didn't he admit that in the grand jury he said the defendant did not pull out a knife?
I don't recall.
Okay. But, all right, so sorry, I cut you off. You're saying that complete your answer, I'm sorry.
Ultimately, what happens here is none of this evidence or none of these arguments changed the testimony that underpinned his conviction.
Well, and again, I'm not following that because at the very least, Wagners-Cagney having a knife Louis Asak says he's standing over here, not involved, and Fernando Moises says he is in the fight. He's involved in the fight. And now we know he had a knife. That doesn't undermine, there's a clear conflict there between these two witnesses that the jury didn't know about.
That's fine, but I think that's ordinary course for this type of trial. Different people see different events from different angles. It's unclear to me why Trooper COMMONWEALTH believed that Wegmans Kane was subsequently identified as the person with the afro with the knife. I don't know what the basis of that is because nobody else was able to identify it. It's not in the record anywhere else.
So sorry, are you challenging the reliability of Major COMMONWEALTH's identification? Is that what you're saying?
No, I'll withdraw that statement. Now, with respect to Raymond's letter, I think it's also important to note that her letter, it's based on speculation on her part. If you look at her trial testimony, what we have is she sees the initial fight between the victim and defendant. She's worried for the defendant, and she leaves that location and goes to get help. Then she returns after the melee has already ensued, because when she returns, she sees the defendant leaving the parking lot at a high rate of speed in his car.
She never recants, right?
Correct.
Her trial testimony.
Correct.
But isn't it fair to say her description of the initiation of this fight, melee, is dramatically at odds with every other characterization of how it starts, by which I mean specifically, she describes this one-on-one fight between the victim and the defendant, and everybody else, Fernando Moises and Louis Asak and everybody else says, no, as soon as the victim comes out, 5 to 12 people set upon him, and the melee begins immediately.
There are different versions of events from different witnesses who testified.
Right. She alone gives the one-on-one version, and everybody else says it was a melee.
I don't believe that is partly accurate, Your Honor. My understanding, and if you look at Leger's testimony as well, the fight was described as a one-on-one fight that lasted for about 45 seconds. And then what happened after, when the victim won that fight, 10 to 15 people jumped in. I think it's a reasonable inference to make from the transcript that as soon as Ms. Raymond saw the one-on-one fight, she went to a different location to try to get help. She missed the rest of that fight.
Right, but so there was a pause, according to her version, where she went to get help, and then this group of 5 to 12 guys, she gets them, they come over to help the victim, or the defendant, and set upon the victim in the melee. So that again is different, isn't it?
I don't believe that the people that she went to go retrieve were the ones that were involved.
Oh, I see.
I don't think that's clear from the record. I think the record would contradict that statement because by the time she gets back, the fight is over, the victim is on the ground bleeding with his friends above him, and the defendant is fleeing the scene at a high rate of speed.
I just have one last question. When she first spoke to the police, the very first time she described this event, she in fact told them that that the defendant was not involved.
And that's the statement that the defendant had as well. The defendant changed his story. That's not unusual with these types of investigations, that people give one initial answer to the police and then later become more forthcoming.
But the answer to my question is yes.
Yes,
That's right.
but that would have also been that was the subject of cross-examination, that would have been before the jury as well, so I don't see how that would change anything at trial. With respect to the DNA evidence, very briefly, the DNA analysis on the victim's shirt showed that only the victim's blood was on the victim's shirt, so it's not probative of the identity of the murderer. It's not that somebody else's blood was on there and that person would have in fact been the true killer. With respect to Mr. Polanese, he admitted to kicking the victim twice during the melee, so that's how he gets blood on his shoes. With respect to Agnes Cange, he has a small amount of blood on one of his legs on his jeans. Again, there's evidence that he was involved in the melee, which suggests to this court if he was in fact the person who stabbed him, he would be covered in blood, like the defendant was in this case.
I think we're going to have to leave it there, counsel, unless the panel has any other questions. Seeing none, the matter is under advisement. Counsel, thank you both. It's a very complicated case. You both did an excellent job. We're going to take a very brief recess to reconstitute the panel, and we'll be back out to hear the Ladd case.
Thank you.
All rise.